And thank everyone for joining us today in their discussion about COVID's impact on construction. I know this is labeled as construction dispute resolution, but this is primarily related to COVID's impact on construction. I'm Adam Dawson. I'm a partner in Farella, and Martel, and I specialize in construction and real estate disputes. Could you do the first slide, please? And just as an introduction, as I said, this is about COVID and how it's changing the landscape of construction projects. There are a lot of emergency health orders, state and municipalities, shelter-in-place orders, social distancing, and the pandemic is also interrupting supply chains, resulting in price escalations, late delivery, construction finance is reduced, and the result is an increased risk of delay, lost productivity, cost escalation, project suspension, and termination. And I'm going to be speaking this afternoon about delays and loss of productivity. And then my partner, Rick Van Duzer, also a construction and real estate litigator, will be speaking on the other COVID impacts. So could you give me the next slide, please? The delays during the COVID-19 impact, they're pretty self-explanatory. We have construction contracts on one side which say time is of the essence, and they have the provisions that will have particular completion dates. They're often tied to liquidated damages, and contractors can be liable for actual or liquidated damages depending on delay. And the construction contracts also allocate responsibility for impacts or various delays. And with respect to COVID, the provision that is most often discussed has to do with force majeure relating to a delay outside of the anticipation of the participants. Next slide. And with regard to reviewing the force majeure, the specific language of the contract will obviously control. Force majeure terms are often modified during contract negotiations. And although specific terms can widely vary, there are two types of general force majeure clauses. And throughout my discussion, I'll be, to some extent, contrasting the AIA approach with other approaches, but the consensus document approach most specifically. So two general approaches to force majeure is either a non-exclusive list of examples of force majeure delays with catch-all provisions regarding anything outside of either party's control, or an enumerated list of specific conditions that qualify as force majeure delays. Next slide. So you can, to determine whether a global pandemic falls within a specific range, you can look at the specific contract language. The force majeure in the AIA is typically going to be one that includes a non-exclusive list and will have a provision relating to being able to argue as to whether it was outside of the party's contemplation. And the consensus doc typically will have a more inclusive list, which would include such thing. Next slide, please. So the consensus docs, and I'm sorry to the extent these slides are a little off. Maybe Margaret, you could look at the slides and see whether they could be adjusted. They seem to be a little off in the presentation. So as I said before, the A201 delay and extension clause relates to unusual delays in deliveries, unavoidable casualties, or other causes beyond the contractor's control. In the event you can prove that, the contract time shall be extended for such reasonable time as the architect may determine. That doesn't determine whether or not that extension is compensable or not. And the next provision, 8.3.3, talks about how 8.3 doesn't preclude recovery of damages for delay by either party under the provisions of the contract documents. Whether or not a delay is compensable is kind of outside of the ambit of what we're going to be discussing today, but would include, the normal concepts of whether that delay is overlapping with another delay and will be governed by the provisions of the contract documents. Next slide. Again, the slide is needs a little work.
Sorry, it's worse, did you say?
No, it's coming out unclear and there's some letters missing, so it's a little hard for everybody to review. But under the consensus docs, which, by the way, are in my mind a very valuable set of contract documents that are way underused. I would say that perhaps 10% of people using for contracting for construction projects are using consensus docs, but they tend to have a little more detail in some areas, such as this. The consensus doc 206.3.1 says if the contractor is delayed at any time in the commencement of the progress of the work by any cause beyond the control, the contractor shall be entitled to an equitable extension of the contract time, and then gives a pretty good list of some of the things which might be considered outside of the control of the contractor, including transportation delays not reasonably foreseeable and epidemics, which obviously the force majeure and related to COVID would involve. Next slide. With regard to any delay that is triggered by a force majeure, the general requirements regarding notice to the owner under the AIA are 21 days or prompt notice under the consensus docs. What are you supposed to be providing a notice of? In general, you've got to be providing a notice of an event which is outside of the contemplation of the parties, and as I'll get into a little more, the anticipated effect of that event, even where you can't say exactly what that's going to consist of. You've got to make a good faith attempt to give them examples of how the effect that the event is having and how that going forward may affect their work, and what the claims, documents, and development and submission of all that follow your notice. So you want to be able to say, I originally gave notice, I put you on notice of particular events and effects of the COVID-19 delays, and here is the documentation relating to the particular sub areas that I identified. Doesn't mean that if you don't identify everything right away that is going to be the subject of delay that you are not in compliance with contract documents, but it also is not sufficient to simply send a letter saying we're in the middle of a pandemic and that's likely to delay things. Also, remember the general provisions in the consensus docs. It's 6.3.3, and that says the parties each agree to take reasonable steps to mitigate the effect of the delays. So with regard to notice, I think it's also a good idea, along with detailing what you know about the likely areas that are going to be affected by the delay, that you provide some indication of the steps you would like the owner to take with your cooperation in order to mitigate the effects of that delay. And I'm thinking of one example in a development that I'm involved in where the subcontractors who would normally drive in together were driving in separately, and there were real parking issues associated with that because it was a downtown project, and the contractor and owner agreed to lease property around the base of the development in order for there to be parking that was not far away to expedite the subcontractors coming to the project and to keep them working for the full time during the day. And as I said before, under scheduling impact analysis, this is just a note that if you're going to make a delay claim, you're going to have to provide, have provided an estimated cost or probable effect of the delay on the progress of the work. Now, I know that this is somewhat antithetical to where we are now in this process, because who knows how long the delay might last, and who knows what other changes to municipal law might affect a contractor's ability to prosecute the work the way they had anticipated. But I think the rule here is that you need to make your best estimates in terms of the probable effect and the progress, and you need to take reasonable steps, hopefully with the owner's help, in avoiding as much of the delay as possible. Next slide, please. The productivity sort of goes hand in hand with regard to the issue of delay. And as a general matter, the productivity can result when work isn't accomplished as it was originally anticipated, and it can be the result of the things I've talked a little bit about: work stoppages, change in work sequence, and then limited site access, unavailability of manpower, and other disruptions. Some examples, practical examples from COVID-19 construction projects are things you might expect: the more thorough and frequent cleaning, increased supply and maintenance of hand washing facilities, additional staffing because of new safety guidelines required to maintain a healthy work environment, including temperature checks and other activities. Next slide, please. And additionally, the contractors are experiencing diminished labor productivity caused by increased employee absenteeism by COVID disease, potential COVID-19 exposure, transportation issues, lack of childcare, and reduced on-site staffing or shift work mandate because of new social distancing requirements. And I will just close this section of the presentation by giving some examples where I think probably the owner bears responsibility, and probably others where the contractor might bear responsibility. With regard to the safety and the lack of productivity that you're going to see as a result of additional safety or on-site oversight, those things are probably going to be deemed to be, delay which is required, mandatory, outside of the contemplation of the parties, and not something that is the contractor's responsibility. In contrast to that, and this I know sounds harsh and is harsh, if the delay or the loss of productivity is as a result of the subcontractor simply not showing up, it is probably going to be deemed to be the responsibility and something that is ultimately not going to be acceptable, the responsibility of the contractor as opposed to the owner. Can we see the next slide, please? So when you're doing any kind of productivity analysis with regard to whether you're looking at a claim or you're looking to go forward with a claim, you're going to want to do a comparison of the pre-COVID and the post-COVID productivity. And more importantly, not more importantly, but just as importantly, you're going to have to look at whether or not the expected productivity was reasonable in the first instance. So as it was bid and as it was scheduled, was the contractor actually going to be able to prosecute the work given the staffing at the rate that was anticipated by the bid and the contract? A good indication of that is how things have gone when there was not the pandemic. And you can then see how that varies by comparison with how things went post-COVID. Now, the documentation with regard to all of this is crucial, because how are you going to really do that side-by-side analysis? You're going to have to keep the daily progress records. You're going to want to see daily reports about who's on site and the personnel involved. You're going to want to do webcam footage and progress photos that are annotated with dates and times and location. And importantly, you're going to have cost records documenting the pricing of any loss of productivity. With both loss of productivity and just as a general remark about delay, obviously COVID is causing disruption to projects, but it shouldn't be used as a mask for productivity issues or delay which pre-existed the COVID pandemic. And so, really to get into an analysis, you have to see where everyone was, whether it's late February, early March, when you started feeling the effects of the pandemic, and determine at that point, where was the contractor in the progress of the job, and similarly, what kind of productivity was the contractor going to receiving at that point versus what was anticipated versus what is happening now on the job. So with that, next slide, please. Add to this that the contractor has got to comply with all laws at its own cost, and that the contract price or contract time should be equitably adjusted by change order for additional costs or time needed resulting from any change in law, including increased taxes and then enactment of the date of this agreement. What does this mean? It means that if the municipality comes in and changes the way in which a contractor is able to prosecute the work, either by additional requirements or by stoppages, that is likely going to be a compensable or non-compensable delay. As I said, well, we can't really get into whether the compensation part of it's going to come, but it is probably an excusable delay. And the effect of that is going to be on reducing, at least on reducing that contractor's liability for any liquidated damage clauses, which have been part of the contract. Next slide. So I'm now going to turn it over to Rick Van Duzer to talk about the disruption in the supply chain and labor unavailability.
Sorry about that, Margaret. Thank you, Adam. So as Adam said, I'm going to talk about two things here. I'm going to talk about supply chain disruption and labor unavailability and how that's impacting construction projects and how that risk and that actuality is playing itself out in terms of responsibility at the owner and contractor levels. And then I'm also going to talk about suspension and or termination of the contracts as a result of the pandemic and the impact that it's having on projects. And so what I would like to start with is the issue of supply chain disruption and labor unavailability. I think if you're a contractor or an owner, you know that COVID-19 has and is going to continue, at least for some time, to dramatically affect the availability of labor in the form of craft workmen, and also in terms of the supply of materials as well as equipment. And as I note here, the issue is not simply contractors being unable to obtain materials and equipment to perform the work. The issue also is with respect to owner-furnished equipment and owner-furnished materials, or in the case of an owner who has retained a separate contract to do some work associated with the project, the unavailability or the inability of that contractor to complete their work and to coordinate their work with the general contractor on the main project. It's a question of availability. It's a question of the timely delivery of materials and equipment to the project. And I think somewhat less obvious, it's also the availability of services and support that projects require. For example, as I note here, inspectors, people who are out to, who need to inspect work on behalf of various public agencies being unavailable or being sheltered in place. Permit departments not having the ability to as efficiently or as quickly review and process permits for work. All of those things have been impacted. And just how much, I thought I would go back and look at a couple of surveys that the AGC performed, one in March of 2020 and one in mid-June, which I believe is the latest that's available. And as you can see here from the chart, in March, just as the pandemic was hitting us and shelter-in-place orders were being put in place by public authorities, 22% of the contractors who they contacted and surveyed acknowledged that they had already been provided a notice by suppliers of material to their projects that deliveries were going to either be canceled or late. And 16% said that they had already experienced delays or disruptions because they haven't been able to obtain the materials, the equipment, or the parts that they required to perform the work. By mid-June, those numbers had gotten worse. As you can see, 38% of the contractors who were surveyed in mid-June, as opposed to 22%, said that they had been given notice by their suppliers that deliveries would be canceled or late. 25% said they had experienced delays or disruptions from a shortage of materials and equipment. And interestingly enough, 24% also said that they were experiencing delays or disruptions to their work from labor shortages. And if you dig deeper into those surveys, you'll see that at least some contractors blamed their inability to obtain appropriate amounts of labor on the unemployment benefit, the supercharged unemployment benefit that the federal government provided as a means of trying to get beyond the pandemic. Others simply lost people who didn't come back to work because they either fell sick or they had family situations, as Adam mentioned earlier. But it's a real problem, and I think one that's here to stay for quite a while. Go ahead and change the slide, Margaret. So what's the starting point in terms of looking at this issue? It's the contract, of course. The contract is going to have provisions in it that allocate the risk of cost increases, of delays between the owner and the contractor. And typically speaking, absent contract language to the contrary, the contractors are allocated and assume the risk of providing and paying for the labor, equipment, and material that's necessary to complete the work and deliver the project on time. And that includes responsibility for wage and price escalation, labor shortages, and equipment availability. And I've noted here the AIA A201 section 3.4.1 provision that essentially says as much. And as you can see, it says otherwise provided, the contractor shall provide and pay for labor, materials, equipment, tools, so on and so forth. Next slide, please. So what should a contractor do in these circumstances? Well, as Adam pointed out, the immediate thing that comes to mind is notifying the owner that you believe your work has been either delayed or disrupted on account of not being able to obtain the material and the equipment and the supplies you need or the labor you need to perform the work in a timely fashion in accordance with your schedule. The AIA form, as it is in many circumstances, wasn't really drafted with a pandemic in mind. And so the language in these provisions is not perfect. And here you'll see I pulled out section 8.3.1, which is the provision that Adam showed you earlier. And you'll see that it talks about the contractor being delayed in the commencement or progress of its work by unusual delay in deliveries. And then it has a catch-all or other causes beyond the contractor's control. I don't believe there has been much in the way of legal precedent trying to define what this phrase means when it says an unusual delay in deliveries, but obviously you could argue as a contractor that your inability to obtain materials in a timely way, provided they were ordered in a timely fashion, has been impacted by COVID due to the inability of those material suppliers to either make the materials that you need or to provide for their delivery to you in a timely fashion. The interesting thing here, of course, is that in many cases, some of these delays and some of the unavailability of materials is being caused by the fact that these manufacturers of the materials are not able to operate their facilities. They're losing workers as a result of the pandemic. Their labor forces are down. Their productions are down. And so is that an unusual delay in delivery? Perhaps not. But if it's not, I think as a contractor, you would argue that it certainly is a delay and an impact that is beyond your control, your reasonable control. And as I say here, it's hard to imagine any court deciding that a COVID pandemic would not be considered somehow unusual or would not be considered to be beyond the control of the contractor. What else do? You obviously seek compensation for any increase in the costs you incur or any lack of productivity you suffer through a change order request and, if necessary, a claim. One of the other things you ought to be thinking about doing is proposing alternatives and substitutions, both for materials, for equipment, and perhaps seeking out alternative suppliers who may be able to satisfy your needs. You'll see I've pulled out the AIA and what it has to say about this, and essentially what the AIA A201 document in section 3.4.2 says is that unless it's a minor change or a minor substitution, the contractor has to propose those substitutions to the owner. The owner has to consent. The architect has to evaluate that substitution and approve of it. And then a change order, assuming there's agreement between the owner and the contractor, or a change directive, if the owner desires, in the absence of an agreement, needs to be delivered. Next slide, please, Margaret. In a grander and a bigger picture, I think the message that I would like to deliver to contractors in particular, but also to owners, is be proactive. Go ahead and figure out what material and equipment hasn't been delivered to your site, figure out where it's coming from, figure out who is supplying it, and look beyond, in some cases, simply the provider of the material or the equipment, but who's providing the parts and the necessary components of some of those pieces of equipment and some of that material, because it too may be impacted. And I know that there have been examples, for example, of projects where equipment, for example, or owners furnished equipment, or even equipment that is the responsibility of the contractor to obtain, has been delayed and is unavailable because the manufacturers of component parts in China, for example, had to shut down, were not as productive, got behind, and were unable to provide those things to the people who are actually manufacturing the equipment that was ultimately going to be incorporated into the work. Obviously, as you need to contact your suppliers, you need to contact your subcontractors to both identify where you've got risk in terms of the availability of materials and equipment, and assess those risks and develop a plan for pursuing them. I think you need to develop contingency plans, including thinking early and often about how you would go about substituting products or materials for ones you think you may have trouble getting or may have trouble getting on time. Contacting alternative suppliers of products and materials, finding out whether they have the ability, as opposed to the ones you're currently using, to provide you with what you need in a timely fashion. Think about whether or not you can perform work out of sequence, or whether you want to kind of slow down the pace of certain pieces of the work so that you match the delivery times that you're able to achieve with the suppliers who are supplying the material and equipment to you. A not so subtle one, but one that I think is often omitted: check your schedules if you're a contractor. Find out whether you have activities in your schedules for material deliveries or for the availability of equipment, so that if there are delays, you can track them and track their impact on the critical path. And as Adam pointed out, have a record of the kinds of delays you're experiencing on account of those things. And then, generally speaking, over-communicate with your owner. Don't just provide them with required notices and requests. Try to solicit their input. Try to get them to identify what they're most interested in. Have a frank discussion about those interests and whether or not they all can be satisfied, or whether something is going to have to give. And I note here, just as a very simple example, is the owner really concerned more about getting the project done on time, or are they worried more about the cost? Are they willing to pay some more money to buy an alternative or a substitution if it means making up time, or aren't they? Without that kind of a conversation and a mutual exchange, you're not going to know how best to go about solving the problem. And then finally, as kind of a last resort, as a contractor, I think you do have to consider, under certain circumstances, whether or not to try to terminate your contract and move on. And I'm going to get to that in a moment. Next slide, please. So that's the contractor. What does the owner, what can the owner do, and what options do they have? Initially, I think you have to assess and consider what's important to you as an owner. Is it time? Is it cost? Are you concerned about safety? Are you concerned about liability for worker or employee exposure to COVID? What is it? And then how do I go about addressing it? Do you try to take an aggressive position with your contractor and to try to enforce your contract requirements? Try to, for example, tell your contractor it's their problem, not yours, if they're not able to obtain the material and the equipment and the labor that they need to perform the work in a timely fashion. Or do you work with your contractor? Do you try to mutually discuss what the risks are, develop contingency plans, identify ways out and to the end of the project that are mutually beneficial, although perhaps everybody's got to give and everybody's got to take. The owner also has the right, as I'm sure you all know, under the AIA documents, to, if the contractor's not doing it, to take over and carry out the work of the contractor. So if the contractor is failing to supply material, it's failing to supply equipment or labor, the owner can, upon 10 days notice, take over that work, carry out that work, but it first requires, under the AIA documents at least, architect approval. And at that point, the owner has the ability, assuming it takes over and spends money carrying out the work, to issue a deductive change order and then to offset the costs they incur against future payables or existing payables owed to the contractor. And then finally, I think considering suspension of the work or termination of, I say the contractor here, but essentially the contract. And hearkening back to that same AGC survey that was taken in June of 2020, the survey results indicated that 48%, almost half of the contractors they surveyed, said that they had ongoing projects, at least one or more, that had been halted, either suspended or terminated. And 54% said they had upcoming projects over the next 3 months after the survey was taken that had been canceled. So suspension of jobs, termination of contracts, canceling upcoming projects is a reality in the world, in the construction world today. I think more so in certain sectors of the construction industry than others, but a substantial sector is being impacted and work is either being terminated or suspended. Next slide, please. So I'll talk a little bit about suspension by the owner for convenience. The AIA documents address this in section 14.31, and it essentially says that the owner has the right without cause to suspend, delay, or interrupt the work. And this is an important piece, and that's why I bolded it, in whole or in part, for any period of time that they may determine. If they do that, the AIA document provides that the contract sum and the contract time will be adjusted for any increases in the costs that result from or are caused by that suspension, delay, or disruption. And that would include profit and overhead. But it also says that no adjustment needs to be made if the suspension, the delay, or the interruption was by some other cause for which the contractor is responsible. So two pieces here that I want to discuss in a little bit more detail. And maybe if you go to the next slide, Margaret, I can address it there. When I'm talking about the advantages and disadvantages of suspending a project by the owner, essentially what it allows, I think, the owner to do is kind of press the pause button, give it some breathing room to try to assess and develop, assess the risks, assess the downside, assess what kind of delays and disruptions it either is or will be experiencing, and develop plans around it. The suspension provision, I think, also provides a great deal of flexibility because it can be invoked by the owner on more than one occasion. The owner can determine how long the suspension should be, and it also allows the owner the flexibility to suspend parts of the project but not others. And that may be important depending upon the kinds of material and the kinds of labor shortages or equipment problems you're having. There may be portions of the project that you can shut down, but not shut down the project completely. It may be that you can shut it down on a short-term basis or on a longer-term basis, depending upon what it is. Generally speaking, I think my advice would be to not use suspension if what you're looking at is what you believe to be a long-term disability or problem. And the reason for that is that under the AIA document, well, there's two reasons for that. One is that it's simply costly. And you run the risk of losing labor that you're never going to be able to get back to your project. There's demobilization costs, there are costs of protecting the work and the site. And as I said, you've got a risk that if you suspend the project and those employees go elsewhere, that you may not get them back. But there's also a risk under section 14.1.2 of the AIA documents, at least, because what that provides is that if the owner suspends, delays, or interrupts the work for a significant period of time, and in the AIA document, it's greater than 100% of the total days scheduled for completion of the project, or more than 120 days in any 365-day period, the contractor has the right to terminate the contract. And if the contractor terminates the contract, as we'll see in a second on this basis, the contractor is entitled not only to be paid for the work it's done, but to be paid for overhead and profit on the work that is to come that it hasn't performed. And that's a significant piece of leverage that a contractor has in any discussion about suspension or termination or any discussion as to how you're going to deal with delays or disruptions that are caused by the pandemic. Next slide, please. Termination by the owner for convenience. Again, this is a long-term, I think, move. I think as an owner, you need to be, sure that you're looking at a circumstance in which your project is going to be significantly impact over a fairly long period of time in order to take this step, but it does allow the owner, if they so desire, to terminate a project altogether for convenience with or without cause. And if it does, the AA documents provide that the owner simply needs to pay for the work that's been performed, including profit and overhead on that work, and any additional costs that's incurred by reason of the termination by the contractor. And you need to be careful and make sure you check your contract to determine if there's some kind of termination fee that may have been agreed to by the owner and the contractor in their contract. When I say no overhead and profit on work not yet performed, you obviously don't have to pay for that as you would under a circumstance that I just described where a contractor is able to terminate. And you would, though, be entitled to profit and overhead on the cost you incur by reason of the termination. For example, as I discussed earlier, demobilization and those types of things. Next slide, please, Margaret. Termination for cause by the owner. This is, as I said, this is obviously something that only a owner who's decided they want to take a very aggressive position with their contractor would even threaten. But the owner does have the right under the AIA documents, section 14.2.1, to terminate the contractor for cause if the contractor repeatedly fails to supply sufficient skilled workers and materials or disregards applicable laws or orders of public authorities. So in this circumstance, if you were an owner and you decided you were going to take a very aggressive position with your contractor and essentially say to the contractor, you bore the risk of any unavailability or any shortage in workers or materials, you need to find your way around it. And if you're not able to supply a sufficient number of skilled workers and you're not able to supply the materials you need to complete the job, I have the right to terminate you under our contract. The second piece of this, I think, is that if you have a contractor who is continuing to perform but is ignoring the orders of the local public agencies, similar to the ones that are in effect here in San Francisco and all throughout the state, if they repeatedly do that, you as an owner also have the right to terminate them for cause. Now, obviously, terminating for cause is a drastic step. It's costly. It's going to delay the completion of the project substantially. It almost certainly is going to resolve in litigation and take some time and cost some money to resolve. So it's not something that you would do lightly, but it's an option available to you. When you do terminate, the AIA contract documents specifically provide that you do not need to pay the contractor anything more until the project work is finished, at which time you can make a decision as to what is owed the contractor, what offsets you might be entitled to assert against any amounts owed, and then either pay or not pay your contractor depending upon how that analysis turns out. Next slide, please. I included this, again, this is the consensus document 200. It addresses this issue in section 11.2. And as Adam said, this is I think a very good set of documents, the intent of which was to try to draw together all players within the industry, owners, contractors, engineers, and architects, to arrive at a form or a set of forms that could be considered alongside the AIA forms, which were obviously architect-driven and owner-driven, and probably, I think everybody would agree, more owner and architect favorable than contractor favorable, and to try to come up with a set of documents that were more even-handed. And you'll see that it's also, as Adam said, somewhat more specific, but it too specifically talks about persistently failing to supply qualified workers, materials, and equipment to maintain the schedule. And it also talks about disregarding the laws or the orders of public authorities having jurisdiction. Next slide, please. Now I want to talk a little bit about the contractor's options, at least as it relates to termination. The first is in section 14.1.1 of the AIA documents. And that essentially says that if the owner stops or if the work is stopped for any, well, for particular reasons, but if the work is stopped for 30 consecutive days through no fault of the contractor, and that work is caused by, and you'll see I've provided for two alternatives here. One is what the AA documents say, one is what the consensus documents say. And so if that work stoppage is caused by the issuance of an order of a public authority having jurisdiction that requires the work to be stopped, you can invoke this provision as a contractor. So as a contractor, if you were in San Francisco and you were working on a non-essential project and the county issued an order, the city and county issued an order essentially shutting down your project, if your project was shut down for more than 30 consecutive days, you as a contractor had the option, not obviously the obligation, but the option to terminate that contract and move on. And that would have been completely acceptable under the AIA documents. It also would have been acceptable under the consensus documents. The thing that the consensus documents adds is it says that if your work is stopped because materials are not available, then that's also a reason why a contractor can terminate the contract. And that arguably is not permitted under the AIA documents because it is not the result of an order from a local governmental agency. And so the consensus documents in this case, I think, provide the contractor with a bit more flexibility. The other thing to keep in mind as a contractor is that there are owners out there who, as a result of the COVID pandemic, are going to be in financial difficulty. And you have the right as a contractor under the AIA documents, if you have a reasonable concern that the owner is going to have the financial wherewithal to continue the project and continue to pay you, to demand that they produce evidence of their financial condition. And the AIA documents provide that assuming you have a reasonable concern and you've made that request for evidence and it's not provided, that that condition is a condition precedent to your obligation to continue to perform. And so as a contractor, if your sense is that A, you want to stay on the project, you want to keep working on the project, you haven't been precluded by a local government agency from continuing with the project, but you have real concerns that the owner does not have the financial wherewithal or ability to pay for what it's going to cost to complete that project under the circumstances in which you've got delays and disruptions, increased costs, material costs, equipment costs, and material unavailability and labor unavailability problems, you might want to consider making a request and seeing how the owner responds to it. If the owner doesn't provide it, you then have to make a decision about whether or not you believe that's going to justify terminating the agreement and, again, getting yourself out of a bad situation. Next slide. I talked already about section 14.1.2, and that essentially says that if the owner suspends or interrupts for these significant periods of time, the contractor has the right to terminate. And the other provision that's similar to the one we just looked at but different is section 14.1.4, and that provides that the work, if the work is stopped for a period of 60 days or more through no fault of the contractor because the owner repeatedly fails to fulfill its obligations with respect to matters that affect the progress of the work, then you have the right to terminate as a contractor. And I identified just two pieces of this particular puzzle. There are projects in which owners are required to furnish certain materials. They may be required to furnish certain equipment. The owner may have difficulty providing it, may not be able to provide it, and therefore may not be able to fulfill its obligations to provide it and to progress the work. And as I said earlier, an owner may have retained a separate contractor to do some ancillary work that impacts the contractor's ability to proceed with the project. in an unimpeded fashion and progress the work. And so under those two circumstances, section 14.14 may provide the contractor with some solace. Next slide, please. Then finally, as I said earlier, contractor termination carries with it the threat of recovery by the contractor for overhead and profit on work not executed. And section 14.13 of the AIA A201 form specifically says that if grounds for termination exist under sections 14.1 or 14.2, and I believe, although the slide does not say it here, I believe under 14.1.4, that the contractor can recover if it terminates from the owner payment for the work that it's performed with overhead and profit on work that hasn't been executed, and all the costs it incurs as a result of the termination. And as I said earlier, this does provide the contractor with a substantial amount of leverage in any kinds of discussions you may have with them over work stoppage caused by material being unavailable or being late, or their inability to provide labor to progress the work, and how you would deal with those circumstances on a going forward basis. The big question, I think, in these circumstances is that leverage that the contractor is ever going to want to exercise and choose to pursue. And my sense is that in most projects, the answer would probably be no, because if there's any doubt that terminating the contract and walking away from the contract is not justified, the contractor exposes themselves to substantial liability for the delays, the disruption, and the increased costs the owner is going to incur in finding a new contractor and completing the work. So with that, I think our presentation is complete.